Thank you, Mr. Chairman, and thank you, Mr. Cordray, for not only being here today, but your commitment to this process. As a former prosecutor, I certainly share with you a deep concern for those who are in appropriate times taken advantage of by some of these instruments. And I'm pleased to see you spending some time talking about the relationship with community bankers. You've developed the idea of how the playing field can be unlevel with respect to those who are unregulated. And you have spent some time talking about how important it is that community banks, in your own words, can provide tailored products and services. They, in effect, know their communities the best. And one of the fears I have is the tremendous authority you have to be looking at any kind of an instrument. And so this fine relationship on oversight. Now, the first question I have is, you are going to be regulating to some extent the banks that are over $10 billion in assets, according to this. But at the same time, we still have 4 agencies, the Federal Reserve, the OCC, FDIC, National Credit Union, are going to be still maintaining their oversight over the community banks. How are you going to work together to assure that we don't have a trickle down, the things that you have, that you're making regulations with respect to either the $10 billion and up, don't trickle down and create a whole new set of problems for community banks? And how are you going to work in concert with all of these other regulatory agencies that still have authority over them?
So, Congressman, I think that's an extremely insightful question, because it's something that we're wrestling with and trying to figure out as we go. And I would suggest that it's a topic that you all should continue to focus on as we go forward over this year and the next, and bring each of the banking agencies in together to talk to us about how are we coordinating, how are we collaborating together, what are we doing to minimize any duplication. For example, the law requires us to coordinate our supervision exam schedules with the other regulators who will still be in some of these same institutions. That's something we're trying to do on a timing basis. We should be coordinating on the kind of guidance or regulations that we're issuing.
Well, you know, as a former Attorney General, one of the difficulties is the most dangerous place to be is between a television camera and one other regulator that thinks they got the big case. So, how are you going to deal with an agency that doesn't want to work with you but says, no, this is our authority, we're going to do this, we're looking at this issue?
If people really don't want to work with you, that creates a problem, because it's not an easy one to get around. But let me give an example. The Chairman mentioned we've just completed a very strong and detailed memorandum of understanding with the Federal Trade Commission, because we do have overlapping jurisdiction. And we had 2 goals in mind here that really came out of discussions we had with the U.S. Chamber. The first is that we should not ever double-team companies. We shouldn't have duplicative actions. By the way, that's not only bad for them, it would be bad for us. It would be a waste of resources. We have limited resources, so,
May I do this? Because I'm sensing to you the commitment to work together. I'd like to ask you, because I have one more question I want to ask.
Okay.
I'd like to ask if you would do 2 things. If you would make a commitment to see the extent to which you can reach memoranda of understanding with some of these other agencies, as well as asking to the extent you can, and I want to nail you down with commitments, but that you will do an impact analysis on when the regulations are made for the institutions above $10 billion, you will do an impact analysis on how it will affect community banks when those regulations or other determinations are made.
I made that commitment in my testimony on my nomination to the Senate Banking Committee, and we are starting down that road already. I've had a big call with a number of the community bankers through the ICBA last week, might have been the week before last. They're kind of running together a little bit right now, in which we pledged to do that. And with our remittance rule, which we just put out, we've added and proposed further tweak, which is to figure out, is there a threshold below which that rule should not apply, because it really, and that's the approach we're going to try to take generally.
Thank you for that commitment. I have one quick area I'd love to spend more time on it, but you've got tremendous authority when you are dealing with institutions once you determine to do an investigation, and it includes the ability to effectively ask them for all kinds of information, including what you can determine confidential and privileged information. One of the real fears I have is the standard you're going to use before you request confidential and privileged information. And then the second is, in light of the McKesson situation, other things which I imagine you're familiar with from our days as prosecutors, how you're going to protect that against third parties that may be trying to access that.
That's an issue that the big financial firms and not so big have raised with us. It's a concern for them. There is a bit of an omission in the statute where there's a mention of other banking agencies that have a special provision for them. We were not included in that. That's an oversight that Congress may want to look at and may want to fix.
I'm sorry, what is that oversight?
There's a special provision that was added somewhere in the course of the last 10 years that specifies that when privileged information is provided to a banking agency, that does not waive any privilege against third parties. You can continue to, it's very much what you just described in your question. However, instead of simply saying banking agencies, where I think we could fit comfortably, it's specified by name certain ones. We were not in existence then. When we came into existence, it was not noted to fix that provision in the statute. I have said that we would be supportive of that. In the meantime, we're working with financial institutions to try to allay their concerns and help them see that we recognize the problem and we want to do all we can both to do our work effectively, which is important, and to be mindful of that concern for them, which is a real concern.
The gentleman's time has expired.